All right, welcome back. This is the second of the asynchronous lectures for the class that we missed on October 5th. So before we jump into the trust cases for October 5th, let me just make one comment about the Williams material for today. So I've asked you to look at Chapter 6 and thought I would talk about the first part of Chapter 6 today, and then the remainder of Chapter 6 when we have class this coming Monday. So in the first half of Chapter 6 of Williams, he discusses the importance of a point sentence in each paragraph. So we touched on this last time. We actually talked about it. The point sentence, as he refers to it, is not necessarily the first sentence of the paragraph. In fact, it usually occurs, this so-called point sentence, usually occurs at the end of the issue, as Williams describes it, or perhaps at the end of the so-called discussion, as we talked about it last time. But regardless of where this point sentence appears, it is one key sentence that makes the point of the paragraph. I suppose this is what some people might call a topic sentence, or what you may have been told is a topic sentence in middle school or high school or college, but it's not always the first sentence of the paragraph, and it's important to keep that in mind. So Williams says at one point, I like this formulation, he says, your question should not be what's the point of the paragraph, even though sometimes I phrase that to you all in my questions to you about your papers, but rather the question should be not what's the point, but where's the point. In other words, you should be able to point to one sentence in your paragraph that clearly makes the point of the paragraph. And if you can't do that, then your reader might be confused, because whether it's consciously or unconsciously, they're going to be looking for that point sentence in each paragraph. Anyway, that's the I take that as the most important point that Williams is making in the first half of Chapter 6. So keep that in mind, and in class on Monday, we'll talk about the rest of the chapter if there are important items that he discusses in the rest of Chapter 6. And I think there are a couple of things we'll want to discuss. All right, so we're going to talk about the cases for October 5th. I don't know that we'll talk about all three, just because I want to keep these lectures at a reasonable length. We'll definitely talk about Allard. We'll probably talk about Hartman. Not sure if we'll talk about Howard v. Howard. We'll see how much time the other cases take. So Allard is an interesting case, Allard versus Pacific National Bank. We know what happened here. Freeman Allard and Evelyn Orkney are beneficiaries of trusts that were established by their parents, the Stones, right? Pacific Bank is the trustee. So now you're well aware that in many cases, a trustee is not necessarily an individual human being. It can be an institution like a bank, or in some cases, they are called trust companies because they serve as trustees in many cases. The Stones established trusts conveying their property upon their deaths to Pacific Bank to be held in trust for their children and their children's issue, right? Their children's children. So Allard and Orkney are life income beneficiaries of the Stone trusts. They get the income. Upon the death of either of those two, the trustee has to pay income from the trust to their children, right? So if Allard were to pass away, then the income goes to Allard's children. When the children of all of the deceased beneficiary reach 21, right? So if it's Allard and he's deceased and all of his kids reach the age of 21, the trustee then has to distribute the trust assets equally among the beneficiary's kids. So that's the setup. The sole asset here is a fee interest in a quarter block in Seattle. So it's real estate, right? The will gives Pacific Bank the full power to manage, improve, sell, lease, manage, and so on of the property. But Pacific, of course, has to do this under a duty of care. That's understood. The property here was subject to a 99-year lease between the Stones and Seafirst Bank. And Seafirst had a right of first refusal to purchase the property. think you all know what a right of first refusal is. You can look it up if you don't. I'm pretty sure that that's self-evident. In 1977, Seafirst assigned its interest in the property to City Credit Union of Seattle, and 8 months later, City Credit Union offered to purchase the property from Pacific Bank for $139,000. Okay, so Pacific Bank said it would sell, but it wanted more money, right? It wanted $200,000. City Credit offered $200,000. Pacific accepted that amount, and the property was in fact sold. So in September, Pacific Bank told Allard and Orkney about the sale. Allard and Orkney then respond by suing Pacific Bank for breach of fiduciary duty regarding the management of the Stone Trusts. So the plaintiffs sought a jury trial in the case. The court rejected their demand for a jury trial because they said the claim was equitable, which we'll get to in a second. After a trial, the court dismissed the action against Pacific Bank, determining that Pacific in fact acted in good faith and in conformance with its duties. There was no duty to inform the beneficiaries before the sale, and there was no duty to obtain an independent appraisal of the property or open it up to the market. So now we've got the appeal of that case. The first issue is a jury trial or no jury trial. This turns on whether the claim is considered legal or equitable. I think we've discussed this before, but maybe not in the context of the right to a jury trial. So common law claims are usually for monetary damages. By contrast, equitable claims in equity, are to decree. The plaintiff is looking for some sort of decree for someone to act or not act in a given way. So in cases where an aggrieved party does not seek monetary damages, the defendant can simply be ordered to return what he has taken. And the rule is where beneficiaries seek recovery for themselves personally, the claim is a legal claim. Where the beneficiaries of a trust sue the trustee to restore funds to the trust, then the action is equitable. Right? This is just fine distinctions, but important distinctions on when a claim is considered legal and when it's considered equitable. Legal claims, you're entitled to a jury trial. Equitable claims, you're not. You've got to live with a bench trial. The judge is the decider. So here, the beneficiaries argue that Pacific depleted the trust assets by essentially selling the property for less than fair market value. So it's essentially an equitable claim, right? Which would mean no right to a jury trial. As to the substance, Pacific says it actually had authority to exercise judgment and discretion in deciding how to invest the trust assets and a duty to use reasonable care. And of course, it believes that the sale was made in good faith, right? And so it's off the hook. The plaintiffs claim that Pacific's discretion was limited by its fiduciary duty, a reasonable claim, and that Pacific breached its duty in management of the trust for a couple of reasons, right? It's a twofold argument. First, the plaintiffs say Pacific had a duty to inform the plaintiffs of the sale of the property, right, reasonably quickly, and it breached its duty by failing to either obtain an independent appraisal, right, for the value here of the property, or place the property on the open market to see what price it would fetch, right, on the open market. The court essentially agrees with the plaintiffs here, right? Pacific says, whoa, wait a second. You're agreeing with the plaintiffs? The Stone Trusts gave us the power, the full power, to manage, improve, sell, lease, mortgage, and so on. So under that kind of agreement, the trustees do not need the beneficiary's consent before selling because they say that the documents gave them the power to sell. However, the trustees also owe the beneficiaries the highest degree of good faith, care, loyalty, and integrity, right? So Pacific also says that it was obligated to sell to City Credit because City had essentially a right of first refusal. Since Pacific did not need to obtain consent, Pacific says it did not also then have to inform the beneficiaries in advance. What's the point of informing the beneficiaries if it was basically obligated to sell to these folks anyway? Informing them would be to no end, right? There's no reason to inform them because it had to make the sale. The court disagrees, right? The court disagrees with this reasoning, as you hopefully saw when you read the case. The beneficiaries could have offered to purchase the price at a higher price, for all we know, right? Thereby forcing City Credit to pay more. And the beneficiaries wanted to keep the property, right? We know that. Disclosure would have given the beneficiaries the right to the opportunity to try to do that, to try to step in and say, well, we might want to jump in and buy the property and pay a little bit more. In some ways, they're a lot like Morton Minard, right? If you remember from the Minard case, Morton Minard says, I should have had a chance to compete, right? I should have been able to jump in there and make an offer to compete, and maybe I would have paid more than Salmon, or at least that's the way Cardozo sets up the argument. So Pacific also breached its duty by failing to obtain the best possible price in the market. Pacific did not offer the property for sale on the open market or obtain an independent outside appraisal of the property to determine its market value. And the court says you need to do that, right? You need to do at least one or the other. And by not doing one or the other, in other words, not going to the open market, or at a minimum having an outside appraisal come in and tell us what the property is worth, by not doing that, Pacific breached its fiduciary duty. So case is very interesting. Again, it helps us understand the way the relationships work, and the duties that are placed on institutional trustees. So that's it for this segment. When we pick up, I think we probably won't talk about Howard v. Howard. I want to keep these asynchronous lectures short and tight, but we will pick up and talk a bit about Hartman v. Hurdle because it's very short but very interesting and helpful. So that's all for this segment, but stay tuned for the third segment momentarily.